The next case is Alexis Swiniarski. Say again? Swiniarski versus Lorain County Board of Commissioners et al. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know, as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument if that applies here. You can refer to them by initials or terms like the child. We've read your briefs and are prepared to proceed when you are.
Good morning. I'm Attorney Michael Conway. I'm the appellant's counsel. I represent Alexis Swiniarski. My client was a benefits coordinator working for the Board of Commissioners in Lorain County, and she was conducting a bit of a research project after she was made aware from a secretary at the Lorain County Jail that there was some Medicaid and health benefits fraudulent billing going on. My client identified about $250,000 of payments, and only about $60,000 of that money could be accounted for as being legitimate. Money was being spent on prisoners that did not exist. Reimbursements for care, medical care was not being made. She took this information to her boss, defendant Jen Sinatra, and made a complaint about it also to Tom Williams, the county administrator. That was on the 4th of January 2021. A weekend passed and she returned to work. Right away she was suspended and accused of misconduct and terminated a month later. And then she had to be terminated again because the county administrator, by the way, I forgot to reserve 5 minutes for rebuttal. The county administrator, Tom Williams, was not the appointing authority who signed off on her termination, had to be redone. We say that her conduct was whistleblowing is protected by the First Amendment to the United States Constitution as applicable to the state of Ohio through the 14th Amendment. My client cannot be terminated for engaging in protected First Amendment activity. Moreover, she can bring a 1983 claim to vindicate her rights in the Lorain County Court of Common Pleas under 42 U.S. Code 1983, which she did. The trial court received a 12B1B6 motion from the defendant arguing the court denied a jurisdiction over the First Amendment claim, and her exclusive remedy was a statutory whistleblower code section, revised code 124.341. Our position is whether or not that remedy is available, it is preempted by 42 U.S. Code 1983 under Monroe versus Pape and Felder versus Casey, which indicated that the states do not have the right to preempt federal law. My client had a federal remedy, could not be denied her, but that's exactly what the judge did. He did not really get into the merits of the First Amendment complaint because the motion to dismiss was based on jurisdictional arguments. We did not, for example, really get into a Garcetti versus Sarabos discussion about whether or not, my client was a policy maker, which she wasn't, whether or not she's acting like a private citizen when she made her complaint, which she was. Her job description did not include making the kind of research that she did. She was acting in the public interest. She has a good First Amendment claim. That case should not have been dismissed on jurisdiction and should be reversed outright. The second issue is for a Greeley claim. Was my client a classified employee to defeat a Greeley claim? And the defendant argued in a State Employment Relations Board hearing that she was not, and then in this case turned around and said she was. We say they are stopped to change their position, and under revised code 124.11a, my client was an exception to the classified civil service. The county board has a right to hire 4 unclassified clerical staff people, which my client was. The trial court decided that she worked for the entire Lorain County, not just the Board of Commissioners. That's, quite frankly, just making up evidence. My client, every document in this case shows my client was disciplined by the Board of Commissioners, fired by the Board of Commissioners. She worked for the Board of Commissioners. The Greeley claim should not have been dismissed. The next issue is whether or not...
On that issue, were there contrasting facts and evidence? Did the trial court actually make a factual determination she was classified, or did the trial court make that decision as a matter of law?
The court, I believe, made a decision as a matter of law under Rule 56C that she was a classified employee, but I submitted did not have the evidence to do that with.
Was there contradicting evidence on the record?
There was a conflict because my client demonstrated that she was an exception to classified service under Section 11A of Revised Code 124. And the other side even said, they said, no. When they wanted to win a state employment relations board appeal, which previous counsel dropped the ball on by not filing it on time, and it was dismissed for that reason, and the board never reached the merits. But the court said, no, she is classified in spite of the fact Lorain County always maintained she was not when it wanted to win something. My client doesn't have the estoppel problem because she's the employee. The employer has the estoppel problem, assuming its prior representations apply, and there are evidence either way. They have the estoppel problem because they're trying to change my client's status to win arguments in the middle of the argument. So we have a question of fact for trial on that issue. With respect to the civil action based on violation of a criminal statute, Revised Code 24CA012185, it is the defense moved for summary judgment on the theory that my client claimed she was intimidated from doing her job. That's not the theory we pled. We pled she was hampered by Jen Sinatra, the HR director, by her filing a bogus letter of termination that actually increased the offenses after my client complained about the illegal billing practices. She added ground for termination, which my client rebutted completely in her affidavit, and that affidavit's never been contradicted. So the trial court said, well, we can't have public employers, so many words, I'm paraphrasing, being charged with third-degree felonies every time they fire somebody. Well, the problem is we're not charging anybody with a third-degree felony. This is a civil action. And if the terms of the criminal statute have been violated under the relevant code section, which is 23CA012185, my client has a right to bring a civil action to remedy the injustice, which she did. And the court basically is indicating in its treatment of that cause of action, we just don't like the law. We don't want HR people at Lorain County being charged with felonies when they fire somebody. That's oversimplification of a very difficult case that is no bearing on anything. That case should be reversed. Lastly, during my client's lateral hearing, Tom Weber, who was the hearing officer for the county, indicated that he had a problem with my client being part of a bunch of gossipy women talking about another employee behind her back, and that's why he thought it was okay to fire my client. And he couldn't tell me that he owed my client a fair hearing. Now, lateral hearings don't require judicial process in the sense of a courtroom trial, but they do have to be reliable in some fashion, or else they're just nonsensical. There's no point in even having them. My client was basically accused of a stereotype by the guy deciding her fate, who was also an interested party in the case as a witness involved in her termination. And so under Revised Code 4112.02, that is evidence of sex discrimination in a termination-making decision. We're not suing for sexual harassment. The defendant used a sexual harassment stray remarks analysis in its motion for summary judgment, trying to get rid of the case. The judge, when he reviewed the matter, didn't review anything. I mean, he gave basically a 3 or 4 sentence paragraph saying that plaintiff's case, it's not good enough. So respectfully request, in light, I'm checking my time, that's pretty handy dandy. I respectfully request that, in light of, unless there's any questions, respectfully request that this case be reversed and remanded for jury trial. Am I on time? Am I on time?
You'll have your full
That never happens.
You'll have your full 5 minutes for rebuttal.
All right.
Good morning, Your Honors. My name is Lee Prue. I represent the Lorain County Board of Commissioners in this matter. I am before you today as an appellate court, recognizing that your responsibility is to determine the appropriate standard to review this case. Now, we have a case that's before the court that was decided on a motion to dismiss for count 1, and then motions for summary judgment, where summary judgment was granted on the other 3 counts. All of these cases do warrant a de novo review, so the court will then be reviewing all of the evidence that has been brought from the lower court and provided to this court for review. In terms of determining whether or not a motion to dismiss was the correct action that was taken by the court below, the court is to review all the facts are true, but still determine that the plaintiff has not stated a claim that would warrant relief. In determining whether or not summary judgment was appropriate, this court will determine whether or not there is a material dispute of facts. Let me just talk a little bit about that, because Mr. Conway did bring up the concern over whether or not Ms. Swiniarski was a classified employee as a material fact. And what I would like to explain to you as I continue on here is that I don't believe that is a material fact, because it has no bearing on the claims that she's brought. In any case, presuming that there's no disputed material facts, the question is whether or not the defendants were entitled to judgment as a matter of law. So in order to make these determinations, it's necessary to look at all of the claims that were brought by the plaintiff, and she did bring 4 claims. The first one being a First Amendment retaliation claim. Now, the court below did a determination considering the possibility that what was actually presented before it was actually a veiled whistleblower claim, which ought to have been heard in the state personnel board of review instead of in front of a trial court. And the court, in my opinion, correctly determined that it was in fact that type of a complaint. So I don't believe that the court erred in determining that Ms. Swiniarski did not have jurisdiction, did not have subject matter jurisdiction to bring the complaint before the court, the common pleas court, because it should have been brought in front of the state personnel board of review. And none of us, including presumably Ms. Swiniarski, have any control about the fact that this matter was not decided on the merits by the state personnel board of review. That's not our concern. That's something she needs to take up with her attorney, who apparently did her a misservice in engaging the case. Nevertheless, because I wanted to make sure this court understood that it could be interpreted to actually be a First Amendment retaliation claim, the board did make a determination for this court explaining what the elements are in order to make a First Amendment retaliation claim, namely that an employee would have been engaged in speech that's protected by the Constitution, that he or she experienced an adverse employment action, that there is a causal connection between the speech and the adverse employment action. In this matter, I want to stress that we don't really have any facts from Ms. Swiniarski. When she filed her complaint, she laid out a number of assertions, none of which are sworn testimony. But when she filed her brief, she basically took her statement of facts from her complaint and incorporated that as her statement of facts in her appellate brief. The problem with that is that we don't have any indication that any of those were proven. The proven and the sworn testimony comes from the depositions that were filed along with this case. I understand there's an affidavit, but there are also statements made by Ms. Swiniarski in her own deposition. There's deposition testimony of Ms. Sinatra, there's deposition testimony of Mr. Weber, there's deposition testimony of Mr. Williams. So this court does have a lot of sworn testimony that it can look to determine exactly what the facts are. And I would argue to the extent anything Ms. Sinatra said in her affidavit is in opposition to what would be in her deposition testimony, it doesn't serve justice for this court to consider what she would have said in her affidavit, because of course that's going to be self-serving depending on what it is. So, having reviewed her own deposition testimony, there was a good deal of discussion during her deposition about her job performance. And she did not do anything during her deposition to counteract what was stated in terms of her job performance. So this court has every reason to rely on the testimony of Ms. Swiniarski herself and of all the other people that were deposed in determining that she did not perform well when she was at her job. So because of that, it would have been incumbent upon her to produce facts stating that the Lorain County Board of Commissioners would have a pretextual reason for terminating her as opposed to terminating her for her bad performance. They never did anything like that. There's nothing like that in the record. There's nothing like that in any of the allegations in the complaint, and there's nothing like that in any of the deposition testimony. So because of that, her claim, whether or not it would have been an SPVR whistleblower case or a First Amendment retaliation claim, has to fail because she has not produced the evidence necessary to be able to make it. I want to move now to the Greeley argument because that's an issue that was specifically made relevant in Mr. Conway's argument. In order for this court to recognize a Greeley claim and determine that one has been sufficiently alleged, the elements to demonstrate that are that a public policy existed, that terminating employees in the manner in which Ms. Swiniarski was terminated violates that public policy, that a causal connection existed between the termination and the public policy, and that there was no other overriding cause for her termination. Now, this claim is not available to plaintiffs that are classified employees. Case law makes that clear. However, whether or not Ms. Swiniarski is a classified employee or she's an unclassified employee doesn't matter because she cannot satisfy the elements of a Greeley claim nevertheless. She has not demonstrated that there is a causal connection between her termination and the public policy, which I am assuming in this case ends up being whistleblowing. And I will be perfectly frank with the court. I did not find the complaint to help anybody in this process, the defendants or the court, specifically explain what factors actually gave rise to a Greeley claim, what specific actions were taken. And because there was no additional evidence provided in the appellate brief, we still don't know exactly what kinds of actions Ms. Swiniarski might be pointing to suggest that she in fact has a Greeley claim. However, you do have the Board of Commissioners record that was detailed very thoroughly in the statement of facts indicating that there is a very distinct reason for which she ended up being terminated, and that was her poor employment performance. In addition, again, because she can't demonstrate a causal connection because of the evidence that's been pointed to, again, this claim, it doesn't matter whether or not she is classified or unclassified, whether she's unclassified or
The
not.
trial court decision, it was based upon her being a classified employee.
I'm so sorry, can you say more?
The trial court decision on summary judgment on this issue, was it based upon her being a classified employee, or did they go into the merits of the claim?
No, they didn't go into the merits. They determined that she was a classified employee, and I think that's correct. I think based on her own testimony, she testified in her deposition that she had administrative responsibilities, that she was a benefits coordinator.
Was there any evidence to the contrary?
No, there's no evidence to the contrary. Which is sort of the whole gist of my argument before this court, is that we've provided you, as the Board of Commissioners, all the evidence that you need to demonstrate that Ms. Swiniarski has not made a prima facie case in order to be able to bring this claim. She had the opportunity to do so in her appellate brief. She had the opportunity to point to specific facts that this court can take into consideration, and she didn't do so.
Counsel said she was classified because she's one of the 4 people that they can hire that are special administrative staff. And I don't mean to paraphrase, that's my sense of what they're saying, that either of these 4 special unclassified positions the commissioners hire. Is it clear that no evidence on the record supports that?
Yes.
Other than her own statement?
That's correct. It is clear that there's no evidence that supports that.
She made, other than that, her own statement. She made a statement in depositions, or where did that argument come from the other side? She's one of these people.
I'm going to be honest with you, Judge Stevenson, I don't know where the argument came from the other side. It was obviously brought to the court's attention. I didn't see anything in the record indicating that.
Not in an affidavit, not in a deposition where she's making that comment.
I don't know, to be honest with you, I'm not entirely sure. It might have just simply escaped my notice. It's possible.
Okay.
I can just stand here before you and represent to you that that's not anything I have known.
To your knowledge, no, but obviously, I mean, I appreciate you telling me to your knowledge, no, you don't see that anywhere.
Okay. And even if she was a classified employee, if she was an unclassified employee, this claim simply can't be met. The evidence is not there to demonstrate that she was terminated for a reason that.
Well, the trial court didn't base its decision on that basis. So if we were to say there's a question of fact, whether she was or was not a classified employee, should we even reach the other question that you're referring to? That's not part of the trial court decision.
No, I don't think that it's necessary. I think this court, because it's general review, the court doesn't necessarily have to look at what the trial court did. This is in a situation, for example, where there's testimony taking place before the court can read people's faces, make a determination as to whether or not there's truthfulness or not. This court, having all of the evidence before it, can make its own determination. And really, weigh the evidence is what I would ask this court to do. Because the evidence is much more strongly in favor of demonstrating that she was a classified employee.
Well, that's not summary judgment, though. Not much more strongly. There's no evidence on the other side. No court should be weighing summary judgment, right? If there's evidence to weigh, it can go to the jury.
Here's what I would say to that, Judge Stevenson. Even if there is evidence that she's a classified employee, she still can't make the grievance. She can't do it. There's simply no evidence that the termination had a causal connection to her perceived whistleblower actions. And I also want to point to the whistleblower actions because I do reference that thoroughly in my brief, in my statement of facts. And I don't necessarily want to insult this court by determining that you don't know what the facts are. I'm sure you've read the entire briefs. I'm sure you've read a lot of the transcripts. The evidence having to do with this whistleblower activity had to do with a determination of the possibility that an employee of the sheriff, not even an employee with the Board of Commissioners, but an employee of the sheriff, may have made some mistakes in terms of how billing took place. And in her deposition testimony, Jen Sinatra ended up addressing that herself, saying we did end up calling Medical Mutual and we ended up getting this taken care of. There's no evidence anywhere that's been submitted. If there had been some sort of an investigation, if there had been some sort of a law enforcement involvement in this action, then she might have a stronger claim that there was in fact fraud taking place and that she did in fact blow the whistle on it, but we don't have anything. Again, this isn't even an employee that is a member of, or that is employed by the Board of Commissioners. So, the final claim that she makes in terms of her complaint is her claim for sex discrimination. And again, there is exactly no evidence whatsoever that Ms. Swiniarski experienced any kind of discrimination on the basis of sex. A few stray statements by Rob Weber, who was a hearing officer, who testified in his deposition that he did not interact with Ms. Swiniarski on a daily basis. That if he happened to see her in the hall or something like that, he might say hello. That they didn't have jobs that interacted with each other. That he was separate and apart from her. Does not constitute an action either for hostile environments. Certainly doesn't constitute anything concerning quid pro quo. And in terms of the possibility of a discrimination situation where she is a member of a protected class, where she experienced an adverse employment action, where she was qualified for the position, and then she was replaced by somebody outside the protected class, she can't make a claim along those lines either, because she was replaced by another woman. So there's no indication here that in fact she was terminated on the basis of her sex. Is it possible she was disliked by Rob Weber? Maybe. But that doesn't constitute somebody being in a protected class. That doesn't create a cause of action if somebody doesn't like you and they decide that you are going to be terminated. Apart from that, I don't have anything further to discuss with this court. If you have any questions, I'm happy to accept them. Otherwise, I will reclaim my time and allow the court to simply review my brief for consideration. Thank you very much.
Again, you'll have your full 5 minutes for rebuttal.
Thank you. May it please the court, I have several rebuttal points. First of all, with respect to the jurisdictional argument, opposing counsel says that we're relying on our pleadings to make out our case in the appellate brief and below. Well, yeah, they filed a 12B1 and 12B6 motion. That's the issue. The pleadings are the issue. That's what's being tested. So it doesn't move the ball for them in terms of scoring points with the court by saying you relied on the complaint, because they put the complaint in issue with a 12B6 and a 12B1 motion. Second rebuttal point is that the other side says my client didn't, apparently I think they wanted her to bolster her case in her deposition about, her job duties and why she was fired. She's not required to do that in her deposition. She's only required to answer the questions that she was asked, which she did. There's no evidence she contradicted anything with an affidavit. But the idea that she's the burden of proof to testify against herself in her own deposition is quite frankly absurd. That's not how Rule 30 works. With respect to the claim that my client's not a classified employee, the other side put that in issue, and the judge wrote an opinion saying that he's aware that, and this is at page 17 of my principal brief, that judge is aware that the other side claimed, the county claimed my client was not a classified employee before a government agency, the State Personnel Board of Review. Now that's a claim made before a government agency. It's not even hearsay. And he's saying that in his opinion that the court finds as a matter of law that plaintiff Swiniarski performed administrative duties for the Human Resources Department for all of Lorain County as a benefits coordinator. He's basically changing my client's job description so the other side can win. My client worked for the board. Every document in this case shows she worked for the board. And as I briefed at page 17 under 124.11a, the revised code, my client is accepted as a classified employee. Now, prior counsel, I was not counsel, had nothing to do with SPRB appeal. That's not my show. He may have made that move to get jurisdiction.
She's accepted under what provision of the code?
I'm sorry, Your Honor.
So there's a list of exceptions.
Right.
She's which one?
Revised code 124.11a8. 4 clerical administrative support employees for each of the elective state officers, 4 clerical administrative support employees for each board of county commissioners, and 1 such employee for each county commissioner, and 4 clerical administrative support employees for other elective officers, and each of the principal appointed executive officers, boards or commissions, except for civil service commissions. Those are exceptions. My client was not a classified employee for the purposes of the Greeley claim, and as far as the argument, she couldn't win on the merits anyway. Apparently they're taking back their 12B or their Rule 56 motion now, claiming on appeal rebuttal that she couldn't win the Greeley claim is not something that was briefed below. The court never reached that, the other side never briefed it. My client made a complaint about a crime taking place at work, someone stealing money. She was fired immediately. She was suspended a day later and fired 2 months later after being suspended. How on earth can they argue there's no causation? Temporal proximity is pretty much right there. You made a complaint about a matter of public concern outside of your job description. The next thing you know, you're suspended, falsely accused of not doing your job, and then you're fired. Bam, bam, bam. That is retaliation, and a jury will surely find that. And as far as the claim that she was a poor performer, that's just nonsense. And my client rebutted every single accusation against her and can prove it. Oh, one thing I'd also point out, working on another case, I was dealing with a client who was fired for reporting a crime to the supervisor in this court in the McKnight versus, I think it's McKnight versus Goodwill Industries, I think that was the caption. No, it was McKnight. Said you cannot fire somebody because they reported a crime. It violates Ohio public policy. This court said that. When my client's accusing the Board of Commissioners of engaging in fraudulent finances, or the Sheriff's Department engaging, and Lorain County engaging in fraudulent finances, and again, this isn't a complaint about my client being unhappy with their job. This isn't a complaint of having a beef at work. She pointed out financial fraud, hundreds of thousands of dollars of it. And this court has said when an employee who's at will makes a complaint like that, you cannot fire them because they did it. That's where we're at.
And you're out of time, so if you could wrap up in the next 10 seconds, that'd be greatly appreciated.
In light of the foregoing argument and analysis, I respectfully request that this court reverse this case and remand it for jury trial.
Thank you.
Thank you.
Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and the decisions are posted on the Ohio Supreme Court website. Thank you again. This court is now adjourned